Today, Attorney Haber, who's from Boyd's, Maryland, and also the moderator on this set, questions Attorney Khurana on new H-1 petition filing after the 221G visa refusal at the U.S. consulate. Let's join these two gentlemen in their question-answer session.
Welcome. My name's Kenneth Haber. I'm a former Assistant United States Attorney, and I'm a former Senior Attorney of the Office of Inspector General, United States Department of Health and Human Services. That's the Prosecutor's Office and the Cop's Office. And with me today is Ramesh Khurana. Ramesh is here to elucidate on some of the more esoteric areas of immigration law. He's one of the most experienced immigration attorneys I know, and he has a practice that scans the globe. People from across the world come for his services because he is the type of person can meet their needs. Welcome, Ramesh.
Thank you, Ken. I appreciate it.
This is the Capitol Forum. Ramesh, can you elucidate on the 221G petition for the H-1B visa filing?
Ken, yes. I would be happy to talk about 221G, but everybody who is practicing immigration or who are the beneficiaries or petitioners for filing any kind of immigration related benefits, they hate the application of 221G.
Why is that?
They don't want to hear it. You know, I tell you, whenever a person goes overseas for the purpose of issuance of a visa in his or her passport, and if the consulate officer thinks that he needs some more time to verify the documentation and other things which are stated in the petition, which has been approved already by the service center in the United States, and he would say, I am going to issue you a letter which would say this is under administrative processing under 221G.
What does a person have to do after that?
You know, sometimes people get out of this mess in a few weeks, but sometimes I have seen people get stuck.
How does that affect their employment?
You know, in fact, this is just the step one. What happens is, as part of step 2 under 221G, the consulate officer has even the authority based on his understanding of the case and investigation of the case, because he has interviewed that applicant first time. Service center here in the US doesn't get a chance to interview the applicant. So when he verifies certain documentation, maybe work experience, maybe education, or sometimes these people are working for the consulting company, and these are the ones who are getting most often 221G letters. And as I said, the second step is that the officer can go even to the extent of saying that I am going to basically send my recommendations to the service center for revocation of the approval of this petition.
Wow.
Yeah. So if that happens, of course, then what happens is, if that step has taken place, it comes back to the service center either in Vermont or in California, and those recommendations get reviewed by the service center. They may revalidate it, or they may agree with the recommendations of the consulate. So it may take many months. You know, this is how the situation gets messy, and that was the reason in my opening comments I said everybody hates to hear 221G, but we have got to deal with it.
Oh, I would imagine if it takes this long, he might lose the employment opportunity. Can a new employer pick him up and continue on with the process?
I like your question. That's the way to deal with the situation. Let us say that you are working with a consulting company and there was an issue regarding employer-employee relationship, or whether you are really working with the end client situation, there was no evidence. So if that is the kind of situation, even if you have been issued a 221G refusal letter, I think the best solution is contact any other employer who is willing to file another petition. At that point of time, it does not even matter that this petition is already pending. You just go ahead and convince your employer, and if employer is willing to sponsor you, he is going to file another petition. If it is approved, then approval will be conveyed to the US consulate and you go for interview again. And most of the times I have seen that these new employers are the vendors who are working between the end client and the consulting company, or basically they are the end clients, and their financials are pretty strong, and probably they have better profile, and it's very easy to prove the employer-employee relationship in those contexts, and then people are able to come back.
Well, that's good to know.
Yes,
I take it that was in part, the denial is in part due to the weak financials of the employer, that he might not be able to continue the employment process?
You know, when we say weak financials, frankly speaking, I have never seen any petition being denied based on the fact that financials are weak, because it all depends under the totality of the circumstances. Because at the same time, when a person is working on H-1B, he is also going to produce some revenue for the company. So that is also taken into consideration. But the main factors are whether there is a proper letter issued by the vendor, and how it is documented that you are really working with the end client. And because most of these consulting companies, they won't have even commercial locations. They have their corporate offices from their home addresses, and this is how the eyebrows are raised. This is a kind of red flag, and consulate officer says, okay, so there is no commercial office, and employees you are showing, they are just 2 or 3 employees. You are not able to provide me the pay stubs for those employees. So, you know, evidence is not supporting the petition, and likewise you have no evidence at all that you are really working at the end client location, because most of the end clients, they say we do not want to get into it, we will not issue any kind of letter. If we were to deal with H-1B people, we would file our own petition, so we do not want to deal with it. You know, better you and vendor try yourself to get the petition approved. So that is the approach I am seeing after January of 2010. And these consulting companies, they really get into trouble because of this reason.
You were mentioning pay stubs. This is part of the documentation process?
Yeah, yes, Ken, what happens is when you file a petition for extension of status, now you need to prove that person is in good status. How you can prove? The best evidence is to produce the current pay stubs. So pay stubs would have year-to-date payment which has been made to the employee, and that would show that employee is still working for that employer. Because if employee is sitting on bench, he is not getting paid, then you know it's like opening a Pandora's box. Then so many issues. US Labor Department gets involved in regard to back wages, and all those nasty things happen.
This gets rather complicated.
Yeah. Yes. So it's always good that you prove that person is in status, because whenever you seek additional immigration benefit, or you are transferring from one employer to the other employer, in that kind of situation you say that I am in good status as of today, and then it's a kind of bridge. When you are in good status, you move to the next employer.
I see. Can a person who's on H-1 remotely work from his country while he's been issued the 221G letter?
Yes, Ken, answer is yes, of course. And if a person is sitting overseas, US immigration laws don't apply. And in this internet age, if you can work on a project while sitting in Canada or India, so and if it meets with the requirement of your employer, there is absolutely no problem. So you are waiting to resolve the 221G issue, because sometimes it takes much longer time. And I have seen in my practice employers do not want any kind of disruption because that particular person is working on a project and there is a deadline and the performance has got to be assured by the deadline. So, most likely if it is feasible, he will allow that H-1B employee who has gone overseas to continue to work from his country until that problem is resolved.
Could there, what would be the effect, and could there be a new H-1B petition filed?
You know, if a new H-1B petition is filed by a new employer or the same employer, then of course it is adjudicated afresh. That means whenever an H-1B petition is adjudicated, so there is a standard of adjudication which is based on the preponderance of evidence. So, the officer has to see two factors, one is of course the employer and second is the employee, whether the employee qualifies to do that particular job or not and what is his education. Now, recently one more problem has started that the person who is on H-1B, he must have obtained his education or degree relating to the job duties. Now, if a person has obtained a bachelor degree in pharmaceutical, let us say. Now, if he is working in IT sector, because he has been working for the last 10 years, 15 years, probably he is qualified to do that job, but USCIS has started asking increasingly, show us how your education is related to the job duties. So, then we use some mechanism which is education plus experience. So, combination of education and work experience, because after a 3-year block of work experience, a person gets 1 year. Then you have to go through the evaluation company which has basically made some arrangements with the college professors who are authorized by the dean of the college or university to give credits based on the work experience, and that person will give the evaluation report and say that his degree is in so and so major, which will be relating to, let us say in the IT sector, computer science, information system, etc., and that will work. It is very important nowadays. So, we fix this problem before we file the petition. We know that it is going to bounce back.
I see. Do they use earlier denials against you in a subsequent petition?
Usually not, but again it depends what were the grounds of denials. Most of the times denials would be for the reason which are not related to the beneficiary or the employee. Let us say that it is the employer's profile, or it is a situation of not producing any documentation in regard to the end client. So, employee cannot be held responsible for that. Employee is clean, he has got the college education relating to the job duties and proper evaluation report is there, and it is a specialty occupation job. So, he qualifies. When he finds a good employer who files a new petition, the chances are it will get approved. I see no problem.
Well, I really think that that's added some clarity to this complex issue, and I'm sure that the viewing audience appreciates that. And again, I'd like to thank you for having come in to the Capitol Forum and to elucidate.
Thank you so much. As I said, 221G situation is very troublesome. It bothers everybody, and once you get 221G letter, I'm sure you lose your sleep, but there is a way to handle it, and you should talk to an experienced lawyer if you get stuck in this kind of situation. And all the best. Thank you very much for being with us.
Thank you.
Thank you.